Hello, good afternoon. My name is Mike Homier, and I appreciate you joining us for our business solutions session today at the MTA. I'm sorry we can't do it in person. This is the second year in a row, I suppose, either canceled or doing remote. So everybody is probably familiar with Zoom and remote meetings, and so it will be interesting. We're happy to answer any questions you might have on relevant municipal topics. And I'll just go around the screen and introduce lawyers in our municipal practice group that are with us. Again, my name is Mike Homier. I'm the municipal practice group chair here at Foster Swift. Also, we have Ann Searink, who is also in the municipal group and president of the law firm. Laura Genovich, who is in our municipal practice group. Mike Bloom, who is in our labor and employment section, but does a lot of public employment, labor, and employment issues for our group. And Leslie Dickinson, who is also an attorney in our municipal practice group. So we don't have necessarily a set agenda for the business solutions. We're really here to answer questions that you may have. And we're happy to do that. You can certainly type those questions out, and then we'll be happy to answer them. And we're going to go around here, and the other attorneys can speak as to their specific practice areas as well. I serve as general counsel to a lot of our township clients across the state, as well as some of the other attorneys with me. And so we do, as you know, a variety of different issues for townships, including planning and zoning, as well as infrastructure, water and sewer, and a whole host of other questions that may come up with municipalities. Lately, in terms of hot topics, we've seen an uptick in a lot of cases involving renewable energy, mostly wind turbines and solar projects. I suspect that that's a result of a new administration federally and extension of tax subsidies and other green energy initiatives. The question really becomes for each township, is how your constituents feel about those projects, particularly on wind, but more so now even on solar, where you have large scale projects planned in mostly agricultural or rural communities. And that impact on those who may not be within the wind project itself, but maybe adjacent to it, and would have some adverse impact by those. And so it's important for each municipality to ensure that, to the extent each township wants to regulate that area, that you have a sufficient ordinance both on the solar side as well as on the wind turbine side. And so a lot of my practice lately has been focused on those issues for townships. Ann, you want to go next?
Hi, I'm Sarah. I work with council on general rules, policies, ordinances. I also do a lot of Freedom of Information Act and Open Meetings Act issues. As you know, with the pandemic, there's been a lot of new Open Meetings Act questions with virtual meetings and so forth. So any questions on that, we'd be happy to answer.
Laura?
Great. Hi, everyone. I'm Laura Genovich. I also serve as general counsel to townships throughout the state and special counsel on unique issues like Mike with wind and solar and other issues that come up. And something that I've spent quite a bit of time working with township clients on recently is marijuana business ordinances, and specifically adult use marijuana ordinances. We've seen an uptick in interest in communities, townships who have previously opted out of recreational marijuana and now are looking to opt in, either because there's community interest or due to some of the financial incentives that the state is providing. So what we do is help the township walk through that entire process, from determining what types of licenses it wants to permit, where it wants to permit them, how it wants to do that in terms of what districts or overlay districts and things like that. Setting up the ordinance and ensuring that it complies with the statute for adult use marijuana, which is known as MRTMA, which, unlike medical marijuana, the adult use statute requires a competitive process. So you have to decide between competing applications if you have a limited number of licenses. So we walk through that with townships, helping them develop a competitive process that works for their community. And then we go through the process and help the township get those applications reviewed and follow all the statutory requirements for doing that. So that's definitely something we've been doing more of. I've drafted a lot of marijuana ordinances at this point. So if that's something that piques your interest, please feel free to reach out.
Leslie?
Good afternoon, everyone. My name is Leslie Dickinson. Like Laura, Ann, and Mike, I kind of do general counsel for our municipal clients. I do a lot specifically with municipal prosecutions, so misdemeanor, civil infraction, ordinance and code enforcement issues, as well as zoning, planning, and land use, along with general ordinance drafting, specifically focusing on police power and zoning, wind, solar, as well as marijuana ordinances. Recently, one issue that I've been looking into for a lot of our clients is the impact on the most recent federal funding of the American Rescue Plan Act, which is going to be providing federal funding to local governments throughout the country. It's earmarking approximately $130 billion for distribution to local governments throughout the country. Michigan is set to receive about $4 billion. The U.S. House Committee has actually provided allocation estimates for communities, which can be found online. And a lot of our clients are set to receive quite a bit of money, and we're kind of getting some guidance on what that money can be used for. There are certain restrictions in the statute about what it can and cannot be used for. And when that money must be spent by. So we're looking for some more federal guidance from the Secretary of Treasury on that, hopefully coming up soon. But if anyone has any questions about more information on that funding and what it may potentially be used for in the future, I'm happy to address those questions.
Thanks, Leslie. Mike?
Sure. Thank you, Mike. I am Mike Bloom. I'm chair of our Labor and Employment Practice Group at Foster Swift. Unlike the other panelists here that are broad-based generalists in municipal laws, I am specialized primarily in just labor and employment matters. So I'm much more restricted, I guess, than everybody else that's here. But if it's labor and employment related, I'd be happy to talk through some of the issues. For the last year, as you may expect, I spent a considerable amount of time with COVID-19 questions. Originally with issues coming out of the governor's executive orders and the disability laws and the other various health laws that came in. As we got into this year and now going forward, I think some of the big issues are, they remain to be under the health orders. We still have the Michigan Department of Health and Human Services orders that have just been extended, as well as the MIOSHA final rule that has now been extended for another 6 months. So those remain in place. I'm also seeing a lot of questions on remote work still and how that plays into both the MIOSHA orders and in general as an accommodation to the various health issues that we're seeing. Another big issue that is fairly new, but I think it's going to be big in the next little bit at least, is vaccines and vaccination policies, whether they can and should be mandatory, what the potential liabilities and ramifications for vaccination policies are. So those are the big picture issues that I think are hot in the employment world right now, or any other issues that you may want to talk about. I'll try to help you.
Thanks, Mike. I appreciate that. And you raise a good point. And a lot of our municipal clients have all throughout this pandemic reacted to, I suppose, the limitation or restriction on gatherings, and under the both the MDHHS orders and the Open Meetings Act to ensure access to the public. But you may continue to have questions about what the Open Meetings Act permits currently. And we deal with this on a daily basis. And so right now, at least, the Open Meetings Act will continue to permit virtual meetings through the end of the year, but only for 3 specified reasons. One of those happens to be a declaration of a local state of emergency. And that declaration can come from, I suppose, one of 2 sources, either from the township directly or from a county. And I don't recall off the top of my head, but there's something like 20 or 30 different counties that have declared a local state of emergency. And the reason for that is so that they can maintain transparency and access to local government and still continue holding meetings, because sometimes, depending on where you're at, those facilities are not adequate to both maintain any sort of social distancing and sufficient in terms of the number of people. And we saw that recently with a school board meeting where they tried to do a hybrid type meeting. They in fact moved the meeting to a high school auditorium to try and have sufficient room for both social distancing and a number of people to attend the meeting. The problem was it wasn't big enough, and more people showed up, and they consequently closed the doors on the public, which really puts them at a disadvantage in terms of complying both with applicable health orders to the extent they exist, as well as the OMA, which prevents public bodies from shutting out members of the public. So in our context, when you have a township hall that may not be sizable and we don't know ever how many people might attend a meeting in person, it puts the public body at a disadvantage then of trying to hold an in-person meeting. So, these are sort of policy issues that our municipal clients are still grappling with in how to go back to in-person meetings in a manner that will both satisfy the OMA and also mitigate any potential spread of COVID amongst an unknowing population even. And so that's really an area in which we continue to advise our clients on. Leslie, I don't know, yeah, you can see the question, I think, regarding the Rescue Act. So if you want to address that, would...
Yep, I was actually just typing an answer, but I'll address it over the video. So you don't need to apply for the funding; it's automatic. So payments to each state are going to be made, I believe, 60 days after the state provides certification to the Secretary of Treasury. And those funds will then automatically be distributed to the municipalities based on a certain calculation, proportional percentage based on population by the state of Michigan. So there's no need to apply for the funding. It'll come automatically.
And I can jump in on the MRTMA question, marijuana question that was asked in the Q&A. Thank you, Robert, for that question. The question is whether there's any way to determine licensing under MRTMA that won't result in litigation, because it seems like every time a community opts in, they get sued. And I appreciate that question. I think where we most often see litigation by unsuccessful applicants is where the number of licenses is limited. But often, I guess the best way to protect against that, because if you do have a limited number and you have more people that want them and don't get them, the unhappy people, marijuana businesses are generally well funded. They do have a tendency to litigate. You really want to make sure your process is right. That starts with the language of your ordinance, making sure that it complies with the statute, and then making sure that that process is followed, because the unhappy or unsuccessful applicant will always try to attack the process, that you didn't follow this, your ordinance didn't comply with that. If it's just a matter of the township had the right process, it had a lawful ordinance, it followed that ordinance, and it just reached a decision that this applicant doesn't like, then that applicant is not going to be very likely to succeed in a challenge of that. So far in our experience in representing municipalities that have been challenged, the courts are not inclined to rescore applicants or make a different decision as to which applicant is best. Where there's more vulnerability is in the process. So that would be my recommendation, is to make sure you've got a strong ordinance and make sure you're carefully following both your ordinance and the statute. Communities that don't limit the number of licenses have less litigation because you don't have that competition, you don't have unsuccessful applicants, but not all communities obviously want to have an unlimited number of marijuana businesses.
We've got a question for Mike. Mike, can you see that question?
Yeah, the question about negotiating CBA with the firefighters and the average pay rates for the contracts that are being settled. The last numbers that I've seen, and that would have been last year, were slightly under 3%, so 2.5% to 3%. I don't know what that's going to look like at the end of this year. I am actually negotiating a number of contracts yet before the end of this year. And I've been talking to some of the union attorneys I'm negotiating contracts with. The tricky part is nobody knows exactly how much money they're going to have. And of the money that they have between now and the end of the year and going forward, is it going to be tied to specific purposes, or is it going to be able to be used for wages and collective bargaining purposes? And there's no good answers to that right now. So when you go into negotiations, I think the first set of information requests you're going to get under PARA is going to be not only for the finances for the municipality going back for the last 3 years, which is pretty common, but also digging into what funds going forward are available through the federal government and whether that's something that can be available for collective bargaining purposes. I don't know exactly where this is going to go. So I think we're really looking at a variable here. My recommendation and the way I approach it is to err on the side of caution, because a collective bargaining agreement is 3 years or whatever you reach on. If you don't know what the finances are going to look like going forward next year and the year after, don't commit to it, even if the funds are available right now. And you may get some pushback from the union saying we have all kinds of money right now. But in a CBA, you're going to have to look much further ahead than that and make sure you don't spend money that may not be available for those purposes.
Thanks, Mike. Leslie, I think we have well, maybe we don't. It disappeared now. So Laura, we've got another question for you, asking about, talking about regulating medical marijuana through zoning.
Great.
If you could address that.
Sure, I can do that. That question is from Bill Sutherland. Hi, Bill. Thanks for asking that. So before I was talking about marijuana businesses, retailers, growers, commercial operations, I think your question is talking about caregivers under the original 2008 Medical Marijuana Act, where they're not the commercial business. This is the people who are limited to 72 plants, limited in the number. And you are correct that the township cannot prohibit patients and caregivers, but that the township may regulate them through zoning. There was a case that came out that affirmed townships and municipalities' ability to do that. So you could, for example, zone on at least a forward-going basis where caregivers can operate and reasonable time, manner, and place restrictions for that. So you are correct that you cannot prohibit patients and caregivers. You can, of course, still prohibit both medical and adult use commercial businesses, and you can regulate all of it through zoning now.
Good. So if you are attending, please feel free to send us questions. This is really about trying to answer your questions on various municipal topics, and we're happy to answer them. Laura, if what other, I suppose, hot topics do you think have been important to townships over the last year or so?
Oh, wow, that's a great question because we deal with so many different issues, obviously, on a day-to-day basis, some of which we've touched on, particularly with COVID matters, both in terms of meetings and employment matters. Zoning and land use and enforcing that is always, I think, not necessarily a hot topic, but always an issue that we're helping clients with, and making sure that they have good zoning in place. And making sure that that's being enforced properly. I think that, sorry, I see another question coming in. Might let you speak to that, but yeah, I think that, we're seeing a lot of growth in our communities across the state, and of course townships figuring out how they want to deal with that with zoning. We've had townships that don't have zoning that now want to have zoning and want to adopt an interim zoning ordinance and create a planning commission. So we've had the opportunity to walk through with clients and set up their first zoning ordinance. We've defended litigation that arose out of that successfully, I might add. So I think that we're going to see more of those issues come up as communities continue to grow.
Thanks. We have another question that asks us to share about wind ordinances. Do townships have to allow them? So this is, we get this question often, not only about wind, but about solar as well. There's a provision under the Michigan Zoning Enabling Act that says a township may not adopt an ordinance which has the effect of prohibiting a lawful land use where there is a demonstrated need for that land use. The demonstrated need I'll talk about in a minute, but if the premise is do you have to allow them, I would say generally speaking, yes, to the extent that it's a lawful land use. That doesn't mean that you can't regulate that use, and by regulating that use, I mean draft an amendment to your zoning ordinance which would prescribe those qualifications for that land use the way you would do with any other particular land use. What sets wind farms and wind turbines apart is the impact on the township or townships itself. So oftentimes a wind project will involve a number of different townships spread over many square miles of rural or agricultural property within several different townships. And so it's important to understand how you can regulate those and what the limits of that regulation is until it becomes an exclusionary land use issue. And that is where it has the regulatory effect of precluding or prohibiting that land use. I am not aware yet of any cases in Michigan where a township has regulated a wind turbine where a judge has actually determined that it was exclusionary. And that's likely because when we draft, say, wind ordinances, we do so in a manner that specifically permits those by, say, a special use permit subject to a bunch of conditions that you might otherwise include in a special land use permit review. So things like that we address commonly are the height of the turbine, setbacks, noise limitations, ice throw, shadow flicker. All of these terms are sort of unique to wind turbines. So some of our clients certainly will regulate wind turbines less aggressively than others, and others have decided they want to regulate those to the best of their ability, whatever the limit of their legal authority to do so is. So, when we deal with these ordinances, we're certainly aware of the legal limitations, although those are changing as well. So I'll give you an example. If you were going to regulate, say, noise from a wind turbine, do you do that to the next, say, occupied premise and say, well, the noise limitation cannot be more than 40 dBA measured at an occupied premise? Or do you measure that now from the boundary of that parcel line? And these are decisions that ultimately have to be made by the Planning Commission and the legislative body when they approve it. But there are certainly subtleties in how you draft that ordinance to regulate that particular land use. So we, thankfully, as a municipal practice group, we have been successful in drafting those ordinances, and then in a few occasions having to defend them when there has been litigation filed over those projects. Let's see.
Yeah, we have a question from Teresa in Escanaba Township. Hi, Teresa, about how do you correct rezoning issues if zoning amendments have not been done correctly in the past? Example, amendments have not been made to the township zoning ordinance. I think it's a pretty case-by-case situation, but I think what that speaks to is the importance when you do have a zoning ordinance amendment of keeping your records, keeping your record of the amendment, the resolutions approving it, public hearing notices, and certainly the publication of that ordinance. You know, some people are in office for a long time and not everyone's in office forever. And so you lose some of that institutional memory over the years, and the new officials need to be able to rely on the documentation and the records. So, so I really think that goes to making sure you keep all of that up front. And then when you have a specific, or if you have a specific situation where those records were not kept, sometimes it's a matter of going back and trying to see what you can find in terms of what was published in the paper at that time and what records there are, or deciding how to handle it moving forward so that you clear it up, so that going forward, if there is some uncertainty as to the zoning of a specific property, it gets finalized now so that everybody knows moving forward. That is to say, if you have something that is unclear now, depending on the situation, it may not be, things don't necessarily get better over time. So I hope that addresses the question, and I'd be happy to talk to you about that more separately, Teresa.
Yeah, the next question is from Dawn. Dawn, I'm sorry, I didn't state the two other reasons that you can allow members of a public body to attend meetings virtually, but they are, so we talked about a declaration of a local state of emergency. That would allow the actual public body to continue to hold virtual meetings. The other two are really member specific, and those are if a member has a medical condition that precludes attendance at a meeting in person. And when I say a medical condition, it can be any medical condition, and it does not have to be stated what the actual medical condition is, only that you state that you have a medical condition that prevents you from attending in person. And the third reason is if a member of the board is in the military and deployed, they can attend virtually as well. And in that case, they do not have to give the location from where they're attending for obvious security reasons. So those are the three reasons: local state of emergency, medical condition, or a member of the military on deployment.
Hey, Mike, if I can jump in a minute.
Sure.
One of the things that I've seen recently is sort of going back to basics for municipalities and townships. You know, the COVID's, things have been developing. It's very quickly developing the reasons we can use electronic meetings and go into, you know, use Zoom and other platforms. So one thing that's really important is to look at your meeting notices and make sure they're up to date. We've seen a lot of meeting notices that still refer to executive orders, you know, which have been struck down, which don't refer to the, you know, the MDHHS orders and the new amendments to the Open Meetings Act, and to make sure that they're properly posted on your website. So if you have a website that you maintain either indirectly or directly that has your meeting minutes and agendas, you're required to post those notices of any electronic meeting at least 18 hours in advance, and it has to be either on your homepage or on a conspicuous website. We've seen them sort of buried in your calendar, and I don't think that's going to be acceptable. So make sure that if someone goes to your homepage of your township website, they can see that notice for electronic meetings. And it has to state the reason you're going into. It has 4 things that you're going to need to include. Most of them already include, the directions for the Zoom meeting, but you have to state why the public body is meeting electronically. And that can be for the reasons that Mike has stated. How they participate electronically, that's your Zoom information, how members of the public may contact members of the public body to provide input, and how a person with disabilities may participate in the meeting. I've seen a lot of notices lately that talk about that Zoom information, but don't include those 4 points that have to be included by the Open Meetings Act in your meeting notice. So just sort of a back to basics issue with electronic meetings, just to make sure you're in current compliance.
That's you raise a good point, Ann, too, and I would like to also highlight the fact that you also, if you maintain a website presence, you also have to post a copy of your agenda no less than 2 hours prior to the beginning of the meeting. That doesn't preclude you from amending that agenda at the meeting, but you actually have to post that agenda on your website at least 2 hours prior to the meeting. So you should ensure that that's being done as well, particularly if you're going to continue holding virtual meetings. Our clients, for the most part, I think, are looking at it now on a 30-day basis, particularly where either they've declared a local state of emergency themselves or the county has, and they're continuing to meet virtually under the county's declaration. That even though, for example, I was at a meeting last night where our client declared a local state of emergency that is going to extend until December 31st of 2021. That's because that's the last date that under the Open Meetings Act, you may still meet virtually pursuant to a local state of emergency. And so they may continue meeting virtually until they decide they can go back in person, but they're not required to either. So they're taking it on about 30-day chunks and looking at the data, looking at the positivity rates and other health information to determine whether or not they can have in-person meetings. So, if you're in a county that has declared a local state of emergency, you can continue meeting virtually until that local state of emergency either expires or terminates. And then at the longest period of time until December 31st of 2021. Starting January 1st of 2022, the only reason a member may attend a meeting virtually is if that member is in the military and is deployed and cannot attend in person. So hopefully that answers all the questions about the open meetings, but if you have any, feel free to type them in and we'll answer them. Laura, I think the next question is for you.
Well, I think actually Mike Bloom might chime in on the mandatory COVID shots as well for fire personnel. Mike, do you want to, and then I can jump in on the adult use question that comes after that. Mike, you're muted, Mike.
Might help if I unmute myself. The mandatory vaccination question. The question raises a number of points on mandatory COVID shots for fire personnel and the rest of the employees. It seems like violation of personal rights, but it causes overtime and shift coverage concerns because of the quarantine. There's a number of issues that question raises. The first, I think, is can employers have mandatory vaccination policies? And the answer is yes. The Equal Employment Opportunity Commission and a number of other agencies and experts have indicated that mandatory vaccination testing is not prohibited except in a couple of critical situations. One is if somebody has a medical condition that does not allow the vaccination, they must be considered an accommodation for the requirement of vaccination. So it would be an ADA accommodation to find a solution other than the vaccination. You might also have situations where employees have religious objections to vaccinations, and that would come under Title VII, which also requires accommodation for religious objections. So you do have those two mandatory exceptions. But other than that, vaccination policies that require that all employees be vaccinated would for the most part, be enforceable. The question is, should they? Because there could be liability kicking in there on what a lot of employers are doing right now is they're taking a wait and see. The vaccinations, particularly with the J&J being paused because of the blood clots and whatnot, there's concerns that if you have a mandatory vaccination policy, somebody, because of that policy, gets the shot and then has an adverse reaction that causes serious illness or worse, could the employer be potentially liable for that? And I think that's an open issue that has a lot of employers taking a wait and see approach to that. With respect to the issue of quarantine, the CDC has changed a couple of their guidelines, and particularly with respect to vaccinations. Fully vaccinated people do not need to quarantine if they come into close contact, provided they're asymptomatic. So you do have that issue. There could be, and I don't know if this would fit in with fire, but this might be a situation where the policy could take into consideration where people are placed or if they can work in person and if they're fully vaccinated, that 14-day quarantine for when they come into close contact would not apply. The CDC also has special guidance for critical essential workers. And so for the essential workers that need to work, that are quarantining only because of close contact, the CDC does allow exceptions to that. So those might be a couple of ways to relieve some of the pressure on the overtime if the quarantine is solely because of close contact and not because of symptoms or a positive test.
Great. I can jump in on, there's a question from Deb on, it says, could you provide examples of competitive processes when deciding who receives licenses for adult use marijuana businesses? And that's a great question. The statute doesn't tell us what that competitive process needs to look like. It just tells us that you have to have a competitive process if you are limiting the number of licenses. The standard is that you're determining which applicant is best suited to operate in compliance with MRTMA, the statute, in your municipality. So that raises a couple of, oops, I just froze. Okay, there we go. One is whether the person is suited to operate in compliance with the law, and then or best suited to operate in compliance with the law in this particular community. So what we typically do, depending on how the township wants to approach it, is develop some criteria that we put right in the ordinance for the township board, or if they're designating a committee to decide these applications, whoever the decision maker will be, they will have criteria to apply that directly relate back to that statutory standard. So factors that go into whether they're well suited to operate in compliance with the law in the township might be, have they run a marijuana business before? Do they have a history of violations either with the state or in other communities or in this township? What is their business plan? What is their plan for a number of employees? Are they going to be staffed well enough to meet all of the many requirements under state law and likely under the township's ordinance for operating a marijuana business? So we put those standards in so that it's not just a matter typically of the township just saying this one seems more best suited, right? Because going back to what I said earlier, we want the process to be as impeccable and as fair and transparent and competitive as possible, both because that's what the statute requires, and to ensure that if the township's decision is challenged later, that the process has been very clear from the outset. So that competitive process is not going to look identical in every township. It's going to depend on the community's needs, but generally that's an example of some of the factors that a township might consider including.
Thanks, Laura. I want to circle back to a question asked by Lynn Durant. The question is, if townships cannot pay their board members mileage from home to the meeting, why can authorities do this? I don't know what specific authority you might be talking about. There are provisions certainly under statute for some authorities like DDA and other authorities that allow members, like for instance on a DDA, who serve without compensation to be reimbursed their actual and necessary expenses, right? So there are circumstances. I don't know of one circumstance where that allows for mileage to and from the meeting. The same is true for board members as well, that they can be reimbursed also for reasonable expenses incurred on behalf of the township. But I, at least in my 20 some years representing townships, have never known a township to reimburse mileage to and from the meeting, not for authority members or board members. So I'm not sure if you have a specific case in mind or an authority in mind. Some other authorities could be governed too by their bylaws, where it may not be statutory or a statutory prohibition, but is some board established through some other process where that compensation is dealt with under the bylaws for compensating or reimbursing members for their service to the township. So, you know, it's something that certainly we could talk about offline as well if you want to talk about it further. But I don't think any one of at least the clients that I'm aware of that we have reimbursed for mileage to and from meetings at all. I'm not saying it's prohibited. It just doesn't seem to me to be an actual and necessary expense that would typically be reimbursed. All right, and then there's another question from Treasurer that says, please elaborate about wind company representative making recommendations to Planning Commission about being restrictive. So this is a good question, and I will say, generally speaking, beware of any developer who wants to help you write your ordinance, which would permit their development to move forward. You should look at that with a skeptical eye. I don't think I've been involved yet with a wind project or a solar project where somebody representing the company who has an objective to get it approved hasn't at least once said that it's exclusionary. So, you know, I would expect that to be the case for any particular developer who offers to say write or your ordinance or give recommendations about what it should or should not include.
If I can jump in on that briefly, Mike, I think a related issue that I've seen come up with some townships is that the wind or solar developers want to set up private meetings with township board members or planning commissioners outside of the public meeting context. And although that's likely not prohibited, I think townships need to be aware of, you know, perception that it can create in the community when the developer is having these kind of side meetings with the township. So, and I get when townships receive that inquiry, I mean, you're an official, you want to meet with people. I think one appropriate response is to invite them to attend a township board meeting or a planning commission meeting, even if you're not at the point of adopting an ordinance or something like that, and allow them to give their presentation and information in a public meeting context, but have that in a place where it's all public and transparent.
Great, thanks. Anne, do you want to answer the next question?
Is that the question of, let's see, from Laz Sarabian? Sorry, my last name's hard to pronounce, so I apologize for not pronouncing it correctly.
Yes, that one.
So this one's a tricky thing because I don't think that the Open Meetings Act is carefully drafted. And my panelists may agree with me or disagree with me, but I think certainly if you're holding a meeting because of the public state of emergency, the locally declared state of emergency, you could still allow board members or the members of the public to participate electronically. I think if you are allowing a board member to participate electronically because that particular board member has a medical condition or they are in active military duty, I think that is less clear. To me, it's an interesting issue because I think obviously if you allowed public participation electronically, you'd have more participation. I just think that the Open Meetings Act, the way it's worded right now, is a little bit unclear as to whether that would be permitted under those limited exemptions with medical or with military.
All right. Thanks, Ann. I want to move on to a question from Penny Nelson, who asks, do you know of any novel ideas on managing blight issues? Most problematic are continuing junk at the same property. We're an unzoned township. We have an ordinance with police power. So that's actually a good question, and I'll ask Leslie to jump in if she wants as well. I think one of the most effective tools that we have in managing blight issues is very simple process, but involves adopting an ordinance to designate that violation of your blight ordinance as a municipal civil infraction. The municipal civil infraction can be a powerful tool depending on how it's used. And I'll just give you an example. If you go out and you cite somebody for a violation of your blight ordinance, and it is a municipal civil infraction, you can actually go to court, or the authorized official who cited them can go to court in an informal hearing. And depending on the courts, the municipal civil infraction statute allows these courts to issue injunctive relief. And by that, I mean they can issue an order ordering that the defendant actually clean up the property. That triggers an important part of the due process, because if, for instance, that defendant does not correct the violation within a period of time, then you can actually file a motion to show cause why that person should not be held in contempt. And when we talk about civil contempt, we're talking then about possible incarceration for failing to follow that court order, as well as the imposition of attorney fees and costs against that person. And so most judges will give people an opportunity to correct the problem. But if those individuals continue to or fail to comply with the court's orders, the court will continually then ramp up sanctions. And so, you know, we've had instances where people were actually jailed eventually because they failed to follow those court orders, or they had to reimburse the township all of its costs and attorney fees related to that prosecution. The last thing I'll say is that particularly when you have continuing junk at the same property, it's important to be diligent. That is, your ordinance is only as good as your backbone to enforce it. So if you simply let it slide because you may not want to spend any taxpayer money on cleaning it up, I understand that, but other people then will not comply as well. So it's sort of that broken windows theory, that if you get a number of these properties, blighted properties, the next person doesn't think that they have to comply either because the township isn't doing anything to enforce it. So Leslie, I'm not sure if you have anything to add, but feel free to jump in.
Yeah, the only thing I would add to that, of course, is the option in some circumstances, particularly if it's like a dangerous building situation, that, for example, the housing law of Michigan specifically authorizes the municipality to place the costs associated with if it's a situation where injunctive relief has already been granted by a court and the municipality, the township, has gone on the property and entered after a certain period of time, the defendant has not cleaned up the property, and the township has either hired somebody or entered onto the property itself to do the cleanup, then those costs, and typically attorney's fees if there's been a show cause, can be placed as a lien on the property and collected in the same manner as property taxes. In some instances, and I've had this before, that's enough to push forward a tax foreclosure. Sometimes the defendant is already delinquent on taxes, and of course that the tax foreclosure and forfeiture process can take a while, but sometimes that's enough to push the tax foreclosure into effect. And then eventually the property goes up for, sheriff's sale. And I've actually had a client purchase the property at a sheriff's sale that was blighted and turned it into, a nicer, piece of property. So that's an option as well. Usually it's a pretty extreme if the defendant is just, MIA and not doing anything, but that's another way of addressing long-standing blight issues on a particular piece of property.
All right. Thanks, Leslie. So Carrie Willis has asked a question about public hearings and information included. Carrie, I know that you are a client of ours, and so I will get you that information on what needs to be included in those notices. But generally speaking, it's that information that Ann talked about, making sure that it's both on your website, the reason for the meeting, how people can access that public hearing virtually, if it's going to be a virtual versus an in-person hearing. The next question is about the mileage issue again. And the question is, are you saying they cannot charge mileage transit board members collect for travel to and from home, ? I don't know whether they can or cannot, because a lot of these things are dictated by either statute or by bylaws for any particular entity. So that's where we would look first. And then it's a determination about whether mileage is an actual and necessary expense, either incurred on the township's behalf in the case of board members, or on behalf of the board or authority upon which they sit. All I'm saying is that I don't know of any of our township clients whose members actually charge mileage to and from board meetings. So I think for individual authorities and other public bodies, you have to look at the statutory authority, first determine what is provided and what is not, and then refer to the bylaws of that entity or its organization documents as well.
Mike, you want me to jump in on the next COVID question here?
Sure.
All right, the question is, what is current about how many people you can rent your township hall to? Is it limited to 25 people because of COVID? So we know that the 25-person limit was lifted for public meetings, but that does not apply to other gatherings at township hall. So if you do have an event like a wedding or something else at township hall, as of now, always subject to change as new orders come out, the limit for that in-person gathering would be 25 people.
Okay, the next question, Brian Bowman. Brian, nice to hear from you, is can a township regulate the amount of coverage of solar panels in a given township? I think the short answer is likely yes, that you can limit the amount of coverage the same way we limit the amount of coverage for, say, residential properties and lot coverage ratios, right? How big can your house with accessory structures be on any one individual parcel? I don't see any distinction between that and limiting, say, coverage of solar panels in a given area or a given project as well. So I think it can be done. I think, again, this comes down to drafting skills with this idea in mind that we want to make sure that that regulatory effect does not completely prohibit the use. But in terms of the project itself, you're not entitled to sort of unfettered regulation in that you can regulate these uses, and we just have to keep an eye out on what that regulatory effect then is. But if I said on a piece of property that you can put solar panels on 40% of an individual lot, that is not an exclusionary regulatory effect. By definition, you can put that property to that use, but not all of the property. And so it's not exclusionary. Mr. Sutherland asked, how is a municipal civil ordinance enacted? Is that a public hearing? The answer to that is no, it doesn't. It's generally adopted as a police power ordinance under your authority under Chapter 87 of the Revised Judicature Act, which allows townships to adopt a municipal civil infractions ordinance. So no public hearings required. It's not a zoning ordinance. It is simply a police power regulatory ordinance. The only caveat to that is obviously for charter townships, it has to be introduced and then adopted at a subsequent meeting. Okay. Any other questions? I think we have just a couple minutes left. I am not seeing any other questions. Unless, have I missed any?
Yeah, I think there was a broadband question, Mike, if you go back in the chat.
Let's see.
It says, our township is just in the consideration stage of expanding broadband. Can you give guidance on the best practices for moving forward? And that is from Wanda.
So I construe that to mean that you have some existing broadband, but I'm not sure whether that is, I presume that's a private entity that is providing that broadband. So we've actually assisted several of our clients with broadband questions, some of whom actually built their own infrastructure to provide broadband high-speed internet. In the case of existing companies, we try and work with many of the both big and small companies in determining how we can extend that broadband. I won't go into necessarily the details here, but you know, if that is one of the permitted purposes of, say, federal money under the Recovery Act, then it may be worthwhile into looking into extending that in your more rural areas, and would involve some sort of public-private partnership in extending that that infrastructure. Okay. There's another question. We have a mobile home park within the township. It's currently not licensed as a mobile home park with LARA. There are numerous units that are uninhabitable and a total loss. The units are allegedly individually owned. We have no way of determining ownership. The owners of the park property are 16 months behind in water. The dangerous units have been tagged as such. Any suggestions on how to close the park? So my recollection is that we ran into, this is several years ago, a mobile home park that was unlicensed. And I know that we reached out to LARA and probably the Mobile Home Commission to enforce its regulatory authority in shutting it down. Ultimately, that case ended up with them selling the park and getting relicensed and cleaning everything up. So it was a win. I would argue that if it's no longer licensed as a mobile home park, then it certainly doesn't deserve that protection under either the statute or under your ordinances concerning a mobile home park. And even though the units are maybe individually owned, you may still be able to take action against the owner. Now, I haven't read your ordinances, obviously, but oftentimes when it comes to, say, blight or dangerous buildings, whatever it might be, it's oftentimes that ordinance will say that the person responsible is the owner or the person who has control of the property itself. So when we are asked to enforce issues or code violations, we typically go after both the owners of the units to the extent we can determine that ownership, but more often it's the owner of the property because they have control over it, because this unit is still on their property. So that's where I would start. Not to mention they're 16 months behind in water. I think the the prohibition on water shutoffs has expired now, if my memory is correct. So you may be able to turn the water off as well. So there may be a number of options to start dealing with that. So, and I'd be happy to answer those questions offline as well.
Okay, Mike, I
Okay.
know we're near
We're
being out of time. I think maybe we are out of time. There's one, I think, real quick question. Are employees privy to other employees' wages? The simple answer is maybe. And the reason why I say that, as the employer, I would not provide anybody information on anybody else's wages. It's an employment matter, a personnel matter. As the employer, I would keep that confidential. But for union represented employees, the union certainly could get that information through a para request. And there's two statutes that would prohibit the employer from allowing employees to share that information. One, again, is para, the other is a Michigan statute that says employees have the right to share their wages and benefits with other employees. So even though the employer should not share that information, they cannot preclude employees from doing it on their own.
I do want to add something to that I think is important, because as Mike said, as the employer, you don't want to voluntarily give that information, but just as a piece of information, the Supreme Court's noted that public wages, even attaching the names to the wages, is subject to FOIA under the Michigan Freedom of Information Act. So your employees might be able to obtain that information that way.
Thank you. I know we're out of time, and I know that any one of us would be happy to answer any additional questions that we may not have gotten to or that we left unanswered. I certainly appreciate your time in joining us. I know it's not the ideal format for this, but hopefully we made it somewhat painless. You can find us certainly online, and feel free to reach out to any of us. We appreciate your attention and attending today, and we look forward to seeing you in person again, hopefully soon. Thank you very much.